Okay, so we began by understanding or looking at what is ADR, Alternative Dispute Resolution, for those of us who may be hearing this word for the first time. So alternative dispute resolution, the key word there is alternative. So, and my first statement there reads or says that by the fact that you're calling all these other mechanisms, or this mechanism that we're trying to talk about today as alternative, what are we trying to say? And fundamentally, what we are trying to say is that we want to look outside the courtroom, because again, I think since westernization of the African society, which had very fundamental mechanisms of dealing with disputes, but then again, we became westernized, and I believe that is where our focus to the very formal way of resolving disputes began. So that now from then we were told that for you to have justice, or for your dispute to be resolved, then you have to go to court. You have to go to courts, and you know, through the various laws and regulations, there's a prescription of what is a courtroom, how do you go to courtroom, who talks in courts, by the way. And unfortunately, for most of us, we still believe that you can't even go and take your matter to court. You can't represent yourself in court, because there has to be a lawyer who has been trained in a certain manner, who must dress in a particular way, for that person to be able to assist you to resolve your disputes. So you find that this very formal way of resolving disputes, first we are saying it is not adequate, and then again, it is probably not the best way also, because it fails to look at very many other fundamental issues. It fails to look at even what you want as a person who has a dispute. You go to court, and maybe from the beginning to the end, you'll never even understand what was said. You'll never understand why the orders were given in that particular manner. So you wonder whether that justice, or that decision, or that option that you've been given by the court, does it serve you as a person who had a dispute in the first place? And what we can say is that there has been progressive shift from that mindset. And world over, regionally, and even in Kenya, we are now moving back towards alternative dispute resolution mechanisms. And I have said there are many. I have mentioned what we used to do in the African traditional society. If you go to for instance, the Kamba culture, they had a very strong way of resolving their disputes, and similarly to all the other cultures. So these mechanisms include the traditional methods, and I'm glad that apart from just ADR, judiciary is also pushing for something we are calling AJS, that I would also urge all of us to, gain an interest in, because we can become AJS practitioners, or we can promote alternative justice systems to resolve conflicts within our spaces. So back home, I will mention that the Constitution recognizes ADR, and I believe most of us, if not all of us, agree that whatever we do, wherever we are guided by the Constitution. We cannot run away from what the Constitution says. So in Article 159(2)(c) of the Constitution, one of the key roles of the judiciary is to promote alternative forms of dispute resolution. Not the word there is to promote. So the role of the judiciary is just to promote. The assumption is there are forms of dispute resolution mechanisms that are out there that we can all embrace in our communities, in our spaces. And then Article 48 and Article 25, again, to reiterate that the Constitution talks about access to justice, which is a fundamental human right for all of us in Kenya. So it does not talk about access to courts, which is again a misrepresentation of what all of us know. When you imagine justice, you think courts. But what the Constitution says is that you are entitled to access to justice and not access to courts. So through our discussions tonight around mediation, we are going to see how we are going to be promoting access to justice, especially for the people that work with us or work under us. So ADR is a halfway house between the adversarial court system. The adversarial court system, I have said, a court system is there, yes, but it may not be the best. One, again, because it promotes, a defendant and a plaintiff, a complainant and a respondent. You're like in opposing sides. And it is usually one person wins. When you win, you win. When you lose, you lose. And you can imagine what happens for that person who is losing a case after like 8 years, after 3 years, after so long. What happens really to that person? It is a complete loss. So the advantage about ADR is that it is able to cater for other interests of both parties. And as we will see later on, mediation and other alternative dispute resolution mechanisms allow parties to even propose how they want their disputes to be resolved, as opposed to going to a court whereby you will never understand the procedures, you don't know the law, you don't even know what articles and sections and international laws and treaties and all that mean to you, and yet you're a party. So that is just to give a background about ADR, so that we demystify this business of who is the right person to promote dispute resolution. It is you and I. It is not a judge. It is not a magistrate. It is not a lawyer. And by the way, ADR has got nothing. Well, some forms of ADR have the legal component, but mediation and others have really got nothing to do with law. So you need to put yourself in that space confidently, knowing that nobody will ask you about what you learned in law school, what you learned in Kenya School of Law, or what section of the Constitution are you referring to, or what section of Criminal Procedure Code are you referring to. So Hosea, we can move on. Okay, so ADR is huge. Actually, there are over like 17 methodologies of dealing with disputes. And I know majority of us just know about litigation. A few of us may have heard about mediation. But what I have tried to do here is try to categorize them in different themes. So like for us as HR, before we even talk about mediation, we have the preventive ADR that we practice without knowing. When you're negotiating with the employees, for instance, on something, you've given somebody an assignment, and you're having that discussion on whether it should be submitted at within 1 day, within one week, or there's a team, you've given them an assignment, and somehow you're not agreeing on how effectively they are delivering on the project. So negotiation that comes naturally is part of the preventive ADR. Partnering also, as opposed to leading, a process, and there's another maybe function that feels that this process belongs to us, then we can agree and partner. We have resolved a dispute, there are conflicts. ADR clauses, those of us who are in the legal space, you realize that there are clauses either in contracts, there are clauses either in policies that have an aspect of trying to resolve a dispute if it occurs through either negotiation or through mediation or through probably even being taken through a board. So ADR clauses within our organizations, either in our policies or in our procedures, also comes in as a preventive ADR, so that it prevents whatever issues we have from becoming a dispute. Facilitative ADR, that is one of them, is mediation. I think it comes out strongly there, whereby, as you are going to see, you engage a third neutral party to bring two people who have a dispute onto the table and assist them towards reaching an agreement. Then we have advisory ADR. So there's conciliation and collaborative lawyering, whereby these ones are also governed by particular procedures and processes. And they also form part of alternative dispute resolution. And remember, we are saying that this is alternative to, the common understanding here is alternative to going to court or going for litigation. Determinative ADR, this is where arbitration, adjudication, and expert determination falls. There are also ADRs, but now here, without going into so much details, It's like also a court, because someone will make a decision. An arbiter will come up with a decision after hearing both parties. An adjudicator will also assess the situations and come up with a verdict, which is very different from what mediation is, similar to expert determination. Collective ADR, whereby you have ombudsman schemes provided in various policies or even statutes, whereby there's an established mechanism for an ombudsperson to listen to grievances and resolve a dispute. And then we have court-based ADR. I know we have heard about court annexed mediation, and whereas mediation is not really supposed to be driven by the court in their in undertaking their mandate or in undertaking their constitutional requirement to promote ADR, they have come up with court annexed mediation, whereby when you file a case in court, particularly civil matters, family matters, commercial matters, the matter is assessed and referred to a mediator for mediation. So generally, that is a conceptual view of the ADR spectrum. I forgot to include here AJS, Alternative Justice System. What AJS does, it is recognizing the traditional or the community way of resolving disputes that exists or that has existed. So that today we have a land dispute. The elders in my community are recognized as people who can resolve that dispute with finality. And even if that matter goes to court, the court has a duty to recognize if at all there was any, like we go to court and I say, Richard, why are you taking me to court as my brother? Yet we had sat with the wazes in the village and agreed on how to possibly divide a piece of land back at home. So when we go to court, then the court will not hear the matter afresh. The court may not necessarily look at the laws that are there, but they will actually adopt the decision of the wazes and many other forms of AJS system that exist in our communities. We have border. I mean, we have matatu. We have people in our communities have a way of resolving their disputes, and now more than ever before, even the courts are recognizing that alternative justice systems are there, should be promoted, should be protected, and should even be assisted to become, vibrant. We can move on, Hosea, to the next slide. So our gist of discussion today, as I had said, is understanding mediation. We're not going to all those other forms of ADR. We are going to go to mediation because of its unique characteristics in the way it is structured, in the process, and most particularly in terms of the skills that mediators are equipped with that are very critical in managing conflicts whenever they occur in the workplace. So before we discuss about mediation, I want us to take a bit of time to understand what is a dispute and what is not. Because it is like going to a doctor and you're being given medicine. Before the doctor gives you medicine, they have to go into the depth to really understand what is the problem. So I want us to understand the concept of dispute. And my first statement is that a dispute is a product of an unresolved conflict. So before we get to a dispute, we will have a conflict. And a conflict is just a scenario whereby I feel like I am not satisfied. I myself, I will use Richard a lot because he's my partner in this. So we have a situation and I feel that I am disadvantaged. I may not speak about it. Richard may not be aware that I feel so, but it is there, okay? So long as Richard is not aware that I am dissatisfied in one way or the other about something, then we don't have a dispute, okay? Another scenario is whereby you feel like your interests are under threat. you wake up one day and there's a new employee who has come in the organization, and all of a sudden you feel threatened. This person could even be an accountant or in HR, but you feel threatened. Okay, so at that point you don't have a dispute yet. We have a conflict. So what we are saying is that disputes are as a result of unresolved conflicts. And lesson for us as HR is that we should be always on the lookout to ensure that what we are calling preventive ADR, whenever we realize that there's something is not working, people are not comfortable, then we intervene, and probably using some of the skills that we are going to learn, we can be able to resolve some of those conflicts before they become disputes. Okay, so there's we can go to the next slide and see what we are saying about disputes. So we have given an example there, and allow me just to go through it because it's a quote from a journal. If a consumer purchases a product which they believe is defective, they may respond to such a belief in various ways. Yeah, so you go to a shop and you're given a product, but you think, let's say it's a phone. You think that this phone is not functional, or even a basic commodity, a packet of milk, and you think, "Ay, maziwa pana." So you may respond, for instance, by you can ignore, by the way, which is also one way of how we deal with our issues. You can ignore. You can choose to go and you're like, after all, 60 shillings, nothing much to worry about. Or you can go and complain to the shop assistant who sold you that product. So before you tell the shop assistant, then there is no dispute. Now, what happens when you tell the shop assistant? The shop assistant may insist that hii maziwa ilikuja leo. So as long as the shop assistant does not agree with you that the product was defective, then there's a dispute there. If the shop assistant agrees that hii maziwa enyewe iko na kasoro, and agrees to give you another packet of milk or compensate you, then we have resolved it. There's no dispute in that case. So as long as the other person is aware and they don't agree with you, either partially or entirely, that's when we talk about having a dispute. I can see Anna has raised the hand. Anna, would you want to say something? Anna? Okay, let's proceed. Hosea, we can continue. Okay. So we are saying that for something to be called a dispute, it must have moved past the solitary awareness of one person to a joint recognition with at least one more person. And then both parties need not agree on the nature of the dispute, its origin or its substance, but they must agree that there's a dispute. Both parties must agree that there's a problem here. Okay. And we are saying it is a dispute when there is only partial or total rejection of the other party's claim. So what I was saying is that if the shop assistant offers to give you a packet of milk and you agree, then we don't have a dispute. How about if they say they are giving you the packet of milk and you say, apana, no. You also have to compensate me for the cost of going to my house and having to open the packet of milk, putting it in a sufuria or a kettle, and making the sufuria dirty or the pot dirty, and coming back. And then this shop assistant is like, no, it can't happen. So there now we have a dispute that needs a methodology of resolving it. So when you want to solve, when you're thinking about mediation, then you must be very clear of whether there's a dispute or there's no dispute. Hosea, we can proceed. Okay. So I had talked about one of the fundamental problems we have in the formal way of resolving disputes as being it has many challenges. It does not resolve the dispute per se. Okay, and to understand how a dispute is heavy or is huge, we need to look at the iceberg concepts. I don't know whether we know what an iceberg is, but an iceberg is actually a piece of ice that is normally seen floating mainly in the deep sea or in an ocean. And what we normally see is just a small, like an ice that is literally floating in an ocean. But
Like the
what
one
we are
that
told, or
knocked off
what you know, is
Mercy. Like the one that
like her.
knocked off
Yes,
Titanic. The
like
one
the
that
one that no, exactly.
knocked off. Mm.
Yeah. So beneath, that small thing that we see is a huge chunk, yeah, of mass that is deeply rooted, that is not even, we normally see the iceberg floating, but literally that thing is usually not floating. It is our eyes that actually move on the waves and that kind of a thing. That thing is deeply rooted deeply into the sea. You can't even move it. In your own imagination, you can imagine that hii hata haina shida, tutapita tu juu yake ama kando or around it, only for you to go if you're in that ship and bump into something that you could not have imagined. So when you're faced with a dispute, when your staff have an issue, what you want to imagine is that whatever you're seeing at the top is just it's just it's just a tip of the iceberg. I had given an example of this accountant who reports and the HR is uncomfortable. Someone might wonder, why is the HR uncomfortable that the accountant has come? First of all, these are different career paths. There's no reporting relationship. But if you go deeper into the thoughts of this HR, that's when you'll come to realize what is beneath this person. You will realize that maybe it could be an issue of, maybe even if we are struggling with culture, we are like, wameongezea nani? Wameongezea mkale mwingine. Oh, sorry, wameongezea mwembu ama mmeru mwingine. Acha niache kutumia some other examples here. Ama wameongezea mkamba mwingine. So I'm uncomfortable, not because of the accountant, but because of the culture that we have and the culture that we imagine is being propagated by our managers. Or it could be an issue of unfairness in the, someone is laughing. Yeah. So what we are trying to say is that the beauty about mediation, it allows you to go into the deeper issues beneath the dispute, and that way you will have resolved the dispute in a more effective manner. So beneath a dispute, for instance, we are saying there could be personalities. It could be an issue of personalities, all right? We are differing just because of our different personalities. But depending on how we are taken through reconciling or resolving our disputes, we'll be able to appreciate that actually our differences in person, we'll become aware about our personalities. We will be able to embrace that diversity. We'll be able to understand, oh, by the way, it is not actually the work, or it is not actually the function. It is actually our personalities that are eating us. We'll be able to address emotions. Okay. When you begin to resolve a dispute and you give people a chance to talk, you're able to address the emotional problems that they had. Most importantly, we are able to look at the interest. And I'll be giving another example of how interest play in a dispute. Other problems are self-perceptions, issues of self-esteem, hidden expectations, unresolved issues from the past. We could be carrying baggages from the past, and yet what you can see is a conflict between what I had given as an example, this HR and the new accountant. I hope I am not losing anybody, but I want us to understand that before you talk about resolving a dispute, you should endeavor using skills that we are trained in through mediation, are training on how to look at the underlying issues beyond the dispute that you're facing as a mediator. So we can proceed. I think I have talked so much about that, but there's another good example here of a dispute that could arise in the community. Here we have two neighbors. Okay, we have two neighbors, and there's a fruit right at the there's a tree right at the boundary, and they one is saying that this tree belongs to me. The other one says this not the fruit. This tree belongs to me. The other one also insists this tree is mine. So if you don't know the interest of these people, or if you don't have a conversation with these people, or if you take them to court, yeah, we'll have a lawyer there standing, lawyer representing Richard and the other lawyer representing Mercy, and they will go round in circles talking about this law and I don't know what, producing documents, calling neighbors to come and say, indeed, yes, Ibuti, if you go to the boundary, you know, like 3/4 of the roots are in Richard's land. But what they don't know is actually why these two neighbors are fighting over these trees, because one, if you ask them, they're interested in the fruits. Huyu anataka tu hata sio fruits that is a maana. There's some other fruits, some other berries that there's like a tree. Actually, this is a real example which I have where I stay. There's like a berry tree, sijui inaitwa aje. They are not strawberries, but it's a funny tree that just grows. And kids love those two things. We also used to love them when we were young and growing up. Sasa kama uko na watoto wadogo and their interest is those two things, na huu mwingine ni, you know, a person who is as old as Mercy here, now that Richi umeshanichomea. I'm not interested in those two things. I'm interested in the shade or my compound looking green. Okay. So you see, our interests are different. One is interested in the fruits because the kids are young and they love those two funny berries. The other one just wants a green compound. And so long as you allow the branches to, you know, to grow and cover my compound and I have shade, I'm fine. And so long as you allow the kids to eat these fruits when they're in season, then we are good to go. So that is the beauty about mediation, as opposed to going to court. So what we are learning is, beneath every dispute, another very critical skill that a mediator is trained in is to be able to understand the interest of the dispute, of the parties.
Mary had something.
Yes, kindly.
Oh no, coach, I was just bringing in some fun. I was telling her those fruits are called zambaraus.
Okay.
Zambarao, me, honestly, Mary, thank you. This is zinaitwa aje, but I would only call them in my mother tongue, by the way. But I promise, next time we have our webinar and talent, I'll bring a live example, because I actually have them in my compound, and I don't know why kids love those two things. Zambarao, yes. Okay, so Hosea, we can proceed. I want us to be taking a break at around 7, so we need to move. Okay, so dispute resolution and civil justice. Again, without repeating myself, we need to understand that there's actually, I would call it like a cry for people to be assisted to resolve disputes, because the courts we have agreed are not sufficient. There's a lot of backlog. And by the way, looking at the chart that we have here, when you have a dispute, when there's a problem, when you have a dispute with your employer, with your neighbor, with a contract, when you buy a product, and when you buy a plot, what to a plot, na vile tuko wengi. Most of us, we don't take any action. Why? First of all, we are not confident that even if we take any action, we will get justice. most of the times you will not get justice. Tutapelekwa tu round and round and round and round, and you will not get justice. Or again, if you go to court, it is very expensive. We can't afford a lawyer. And we know that we will be heard probably in 2020, 2013, we'll be heard in 2018. Okay. So the biggest chunk of population in Kenya today, actually the statistics talk about 64%. 64% of adults in Kenya, when they have a dispute, will not take any action. So you can imagine the level of injustice we have in the society. And as long as these disputes remain unresolved, then there are consequences to that. There are relationships that are not restored. We have communication problems. We have all manner of problems. Or people even who will now take action in an informal manner. They'll never be reported, but the action is there. Utakuta huko watu wanafanya vitu za maajabu. Okay, then we have informal negotiation, and sometimes this informal negotiation, someone will end up just telling you, huyu hii hapa achana tu na yeye. Or even the person who is assisting in the informal negotiation is so helpless, they cannot even help. I have been in that space whereby someone comes and tells you, pesa yangu, ya true story by the way, true stories. Pesa yangu hii ya retirement package, kuna mtu alikuja akamuuzia idea wanunue plots ama wanunue matatu. You should know the many retirees who have bought matatu zake. Wanapatana na private developers. Some other to ladies huko and some other to boys there who look like they know what they are doing. And they fleece the amount from these old guys. And they have nowhere to go. So when they come to Mercy or they go to Richard, you try to do a negotiation. But because you're also feeling incompetent, you don't know what to do, unaiacha tu imehang na unaenda zako. Others will go for advice. Where do people go for advice from? Kanisa, bishop, wapi, you know? And still it doesn't work. And then now we have ADR processes where mediation is, and the very least go to court because it's expensive. It requires people who are a bit aggressive, and there's a lot of requirements for you to be able to go to court. So we are saying that the most common response to disputes that arise is for the disputant to take no action at all, which is very, very, very sad. And by the way, it cuts across, and remember that our focus is our organizations. So remember, the reason why maybe people are not performing well or why people are leaving your organization is because disputes are not being resolved. So by learning to resolve disputes or to recognize that there are disputes and taking action, we'll be resolving a lot of problems that we are seeing in our companies and organizations. Again, giving reference to the iceberg. We are seeing people leaving. That is the tip of the iceberg. But the fundamental reason why people are leaving are very different, including unresolved conflicts and resolved disputes. Hosea, let's move on. Okay, so let us quickly look at some of the conflicts and disputes we have at the workplace. And I will allow you to chat a few. We give examples on the chat. I also want to see whether we are following or not. And practically, give us what is happening in your organization.
We can contribute on our chats. What are the types of conflicts that we have in our workplaces? Jed is laughing. Probably there is one that I know that sometimes if you put on, if you decided to copy a colleague's way of dressing or the hair that she had, I'm not trying to say that it happens with ladies, it happens even with men. It becomes a problem. And that is what you said. So you will have a bigger problem, but the problem is actually the hairstyle that you copied from another person. So the iceberg is that one. But it will look like an issue of communication, but it is the hairstyle that you copied, or the dress, or the shoes that you copied from somebody.
So Richie, how do you resolve that?
I will request our audience. We have Mary, we have so many people here to tell us, how do you resolve that such a conflict? Because if you solve the issue of communication, you shall have left the deepest part of the iceberg.
Yeah, thank you, Richard, and thank you for appreciating that our the disputes we have or the conflicts we have are driven by different things, like what the very good example you have given. You'll find that Mary and Winnie here cannot work. They cannot even share an office. And why? Because Winnie imagines that her hairstyle is patented, and because she made it it was made in Westlands, and Mary had has done in Huruma, and they are actually the same. She can not stand working with Mary, and that becomes a dispute. Mary, I don't say that you did your hair in Huruma, by the way, I'm just giving her. And there's nothing with doing your hair in Huruma. We know where to do our hairs. And actually, people in Huruma are more skilled than the ones in West. West for pasa too, and then the hair is not properly well, is not usually well done. Just an example. So communication issues, and communication is a big problem in organizations. It is so sad. Even where I sit, I still look at us grappling with problems that are caused by communication problems, starting with our own leaders, our managers, ourselves. We don't know how to communicate. Well, we keep on forgetting that communication is important. So the way you communicate, and again, without repeating the communication class, because it is wide, with the formal communication, if it is not properly done, it will cause problems. If you don't communicate formally, you're brewing ground for grapevine. People will start gossiping. People will start rumor mongering. And before you know it, there are more problems associated with the rumor mongering. By the time people are done with rumor mongering and grapevine, you're losing a lot of work hours. You're losing a lot of time when people are becoming demotivated, because it could be an issue like maybe transfers. Like for those of us who work in government, we are so worried about transfers. So whenever there's a trigger that transfers are happening and they will be affecting so and so, people freeze. Instead of working, they freeze. They're just waiting for them. They're waiting to actually see the transfer letters and start calling their godfathers and mothers to try and intervene. So communication, formal, informal, written, non-written, and all those type of things. They could result to a lot of conflict at the workplace. Cultural differences, for instance. You put people in a team and then you realize that the team is not working. Okay. Why? Because people come from very different cultural backgrounds. So a trained mediator will be able to unearth what we are calling the iceberg itself. Okay. And we'll be able to to bring these people together, and they are able to solve their differences beyond what they are seeing in terms of culture. There was an interesting example that was given in a session where I was in, and one of the employees was actually taken through disciplinary process because they took leave. They took compassionate leave, which is provided in the policy of 7 days to go for a burial of a loved one. And because of their culture, Waluya, mko hapa. It was not possible, of course, with all respect to the community. I'm just giving examples here and there. They were not able to lay the person within the 7 days of compassionate leave. And this person's attempts to get additional days, I think, was not fruitful. And so what happens, this person comes back later, 10 days later, and it becomes a disciplinary issue. Now, if you contextualize the cultural provisions for some of these things. We have to take this number of days for us to lay a person, and then you understand this person was so critical to this employee's family or life. It could be a parent, it could be a child. And then if you're culturally intelligent in that regard, or if you take time, you'll not see that this person, we gave you our policy, this is what we're HR. What does the policy say? 7 days. If you don't do 7 days, what happens? Issue notice to show cause. So these are some of the things that we are being challenged as HR practitioners. You can imagine even that matter if it goes to maybe to the ELRC, to the Employment and Labor Court. You will not be in a very good position if those kind of issues or explanations came into fore, and the matter was heard by a progressive, maybe judge or magistrate. Some may not be progressive, some could be very modern. This is what our policy who are very modern, but some very progressive person will support the employee. Performance disputes, I don't want to go into the nitty-gritty of that, but again, you feel unfairly evaluated by a supervisor, and you feel like anakuoneanga sana. So a mediator, a trained mediator in the organization will be able to move the two parties, the supervisor and the employee, beyond the perceived biases, because some of them could be perceived. The supervisor could just have a perceived bias, maybe based on, what he or she was informed by colleagues. Maybe you've been transferred into a new unit. Now umeenda pale unaambiwa, at who is that Mercy? Which Mercy? Do you even know? That's how we discuss. Unamjua kweli ama unamwonanga tu hapo amevaa blue. Yeah, so it could be biases. So by the time conflicts are escalating into disputes, a mediator in the organization or a person with skills as a HR for mediation can be able to quickly resolve that and enable the performance process to be managed in a better manner. And a lot of other issues, role ambiguity, you're being given unclear roles, leading to conflicts about task ownership, about accountability, about project coordination. And the mediation approach would be, you'll be able to bring the two parties together and they're able to clarify roles together. And they're very clear now. Moving forward, this is what I should be doing. This is how I'm going to be evaluated. I should be accountable for 1, 2, 3 things. And then we are able to resolve disputes associated with role ambiguity. Discrimination or harassment, maybe an employee is presenting a case for harassment, maybe on the basis or discrimination on the basis of ethnicity, on the basis of religion, on the basis of gender or age. Okay, so the mediation approach, you can, again, through the ground rules for mediation about confidentiality, about interests, about open communication, you'll be in a better position to resolve that kind of an issue, because again, the advantage is the safe space. And we'll be looking at when we look at the key concepts in mediation, one of them is confidentiality. So if you have that as a culture in your organization, then people have safe spaces where they can go and have some of these cases are reported and resolved. Okay, generational differences and many others. I could actually go on and on and on. There are issues to do with the world of work as opposed to the place of work. Our company says working hours is 8 to 5, and we have Gen Z who do not understand why I should be working from 8 to 5. Give me my work, I finish, I get into my other gigs, as I call them, and life goes on. So we have we have so many problems and disputes resolved, unresolved, and the minute we appreciate that we need to be alive to the disputes and conflicts and actively manage them or resolve them, then we will have a better workforce, we'll have better organizations. Thank you. Thank you, Hosea. We can move on. So now getting into the nitty-gritty of what mediation is, we'll move quickly. I need to begin by saying that for us to cover mediation, we need a month. Yeah, we need a month. We'll spend a month and come back for refresher. So what we are trying to do actually is to sensitize HR professionals on why mediation is a plus for all of us. So I will try and cover mediation, not in detail because we may not sufficiently do so. And of course, from there, recommend that we go for certified mediation programs where we can now be taken through in-depth training on how to become mediators and how we can, give back to our organizations or even become private mediators like I am. So mediation is an ADR process where parties resolve their disputes with the assistance of a mediator. So two parties appoint a third party neutral person to facilitate reaching an agreement. And mediation is practical and skill-based. So we'll be looking at the mediation process. The critical point from the other slide, without going backwards there, is that mediation is facilitated by a trained mediator. You have to be a trained mediator for you to be able to resolve a matter successfully. However, some of the mediation skills that you learn, you can use them in the context that we have just discussed. So moving on, we are saying that it consists of neutral and independent third party meeting with the parties who have the necessary authority to settle the dispute. So the parties must have the necessary authority to settle the disputes. This is very critical because you cannot be a party to a mediation dispute if you don't have the authority. For instance, if you're representing an organization or you're representing somebody else without the necessary authority. Like for instance, in an organization, maybe the company secretary or the HR or the CEO could be qualified to be the person who is able to sit at the table to resolve a dispute. Otherwise, you resolve that dispute and you go back to the board with your agreement and you are shown the door. So necessary authority is very, very critical. And again, the parties must be able to consent because mediation is voluntary. Parties must be able to consent that we want to go through the mediation process so that we can reach an agreement. So the mediator going through the process, again, I have emphasized that the mediator is a trained person. The training is mandatory. The skills are mandatory. The process is as important as the skills. The process and how mediation is done actually and conducted is mandatory. It is cast. It is very structured, and any shortcut or any deviation then will not enable you to undertake the mediation successfully. Okay, so we want to do a bit to go through into the practical bit of it. So assuming that today you are a HR representative and you are a trained mediator in your organization, and you realize that, or there are many ways in which the disputes can be brought to your attention. The parties themselves may bring the dispute to you, or by virtue of being a HR, you can reach out to the parties and tell them that I realize that there's this and this, and I would want us to engage in a mediation procedure or process for us to be able to resolve. So it can be party initiated, or it can be initiated by the mediator, whereby you inform. The parties may inform, that the parties may reach out differently. One party may reach out and you may assist in reaching out to the other party. So the mediator, first of all, must satisfy themselves that these people are willing. It is voluntary. It cannot be compelled. You cannot compel. If the parties cannot go through mediation, then you leave them to use or explore other alternative dispute resolution mechanisms. All right. So we have to be very, very clear that mediation is voluntary. If we do not want to voluntarily resolve the issue, then we leave it to the other mechanisms. Like, for instance, if our organization does not want to resolve an employee dispute through mediation, that is the HR or the HR management advice, the disciplinary committees are not voluntarily consenting to resolving the dispute at hand through mediation, then you don't touch that as a mediator. It cannot work, it won't work. Okay, so it begins by, of course, reaching out to the parties, or the parties bringing the dispute to you, and then you have a duty to assess whether the dispute can be resolved through ADR. And the test number one is the issue of voluntariness. We'll be looking at other ways of screening a party for mediation. And then, as I had said, ensuring that the parties are willing and be able to participate. And then now from there, as a mediator, you're trained on how to prepare for a mediation. Okay, you schedule a meeting. There's a procedure for that. And then now, once the parties come, usually there's also a detailed procedure of how you conduct a mediation session, beginning with everything, the preparation, the documentation, which kind of forms or documents should you have, where do you start, okay? After the introductions, you explain it is mandatory, it is a requirement that you tell them that this is a mediation and what does mediation entail. And also you explain to them your role as a mediator, okay, which is very clear again. You're not recommending a solution, no. Very unique, by the way, so that now when we go to resolve disputes in our organization, we are not going to be telling Mary, now Mary, stop copying Winnie's hairstyle. No, 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 no. You don't recommend. You allow the parties to come up with their own solutions. So through mediation, you'll enable the parties to bring the disputes to the table. Through mediation skills, you'll be able to look at what is underlying. Once you've gone through the underlying, you'll be able to assist the parties to recommend what works for them. Then through mediation, again, you'll be able now to see how to assist them to compromise based on their interests. And you'll be able also to move the parties from their disputes, from what they have been told by their, like their parents or their colleagues, to now looking at the interests, yeah, and then coming up with solutions that are going to work. The beauty about taking a dispute through that process is that once you resolve that issue, it is owned by the parties, as opposed to where you're prescribing something that will not work. You'll tell Mary not to copy Winnie's hairstyle, and she will actually make it mandatory now. Every time Winnie comes with a new hairstyle, she will even start copying even everything, even the clothes. Kaende. I know a lot of Kenyan language, but saa zingine hizi vitu tunasemanga they are interesting. Kaende. Copy kila kitu. Okay, because you are forcing them. So forced solutions do not work. Mediation assists parties to come up with their own solutions. And Rich, you gave me a very good example. Hapo sitoki kwa hairstyle. Niko na wewe hapa. Okay, so after having the joint session whereby you do the introduction, what is the disputes, and you hear both parties. Of course, again, there are skills and lots of skills that you're given as a mediator, including listening skills. We'll be looking at that, communication skills, your posture, your dress code, the mood in that room. You're not laughing and giving these funny examples I'm giving. I would not go into a mediation session and start talking about kaende. It will not work. Or start talking about huruma, and it shouldn't come from me. It should come from them. Okay. So it actually needs to be managed in a set of rules for it to work. And again, as I have said, that one we can only learn if we go through the full mediation course. So once you have that joint session, sometimes you're able actually to reach an agreement there immediately. You realize that what Mercy is saying and what Richard is saying is the same thing, and there you can reach an agreement, which is very simple. In most instances, you'll have now to meet the two parties differently. They're called caucuses. So you go into caucus with each one of them. And before you break into that again, without emphasizing the details, you, as part of the briefing, you'll tell them, should we not be able to reach an agreement, I will go into private sessions with you to be able to understand the issue at hand better. And private caucus discussions are private and confidential. So when I come to you and tell you, you know what, why we cannot work with now this is Mary, with Winnie, is actually because she copies my hairstyle. I should not come now to the fore and disclose that that is the cause of the disputes. I will just understand, all right? So it will not be part of our discussion when we meet now with the two of them. So you have joint caucus for you to be able to understand the issues and to be able to understand maybe the damage or the harm that this dispute is causing Winnie, for instance. Yeah, it could be very emotional and deep issues that are now you'll be able to understand how she feels really when she sees Mary with this hairstyle, the emotional damage, the insecurity. I don't know their age, but maybe there's like a guy there who all of them are trying to impress. And now Winnie is feeling threatened because, yeah, there's that dude there who is a potential, suitor. I'm just giving an example. So you'll be able to understand the feelings, the emotions that are associated with the conflict that is to have. And again, as I have said, those discussions held there, again, why it is very important to understand the skills in mediation is they are confidential. You don't disclose. Then after, you can do, it's like shuttle diplomacy, bring them back together. Janet, we can hear your private conversations. Thank you. So you can do that severally until now the parties are able to come to the table and agree. Okay. So once all the parties have expressed their views and interests to the mediator in private, the mediator will try and establish areas of common ground. Okay. So that now when you're going back, you tell them, you agree together. Now this is what I'm going to say when we go back. I'm going to tell Mary that proposal number 1A, that she can probably use the same hairstyle, but change the color or change the length, those are, so is that okay with you? And I agree. Then you go back and Mary looks at it. She could say, yes, fine. Or you can say, between January and March, this will be your hairstyle. Or the hairstyles looking like this you can explore those. But between this time and this time, just leave these ones for me. And then you see whether both of them agree. And if they agree, then you have a written agreement and all the parties sign. So we are saying when an agreement is reached between the parties, the mediator will draft the terms of agreement, ensuring that all the parties are satisfied, and have all the parties to the agreement sign, closing the joint session. And what I need to say is that it could be one session, it could be several sessions. So again, depending on your skills as a mediator, depending on the issue at hand, it could take a varying, amounts of time to resolve a dispute. We can proceed. This is a summary again of what mediation does. And from the scenario I have given is that we try and look at the disputes backwards. You want to understand the past through the private sessions, so that you're able to resolve, the iceberg problems that we have talked about, and we are working towards a future that is acceptable for both parties. So that is just an illustration, and Ozia, we can move on. So we are going now to look into key concepts in mediation so that we don't walk out of this place and say we are mediators. Number one disclaimer is that you must go for training and we must be certified as professional mediators. Okay, so fundamental concepts. Number one is the role of the mediator. I had said that the mediator is a neutral third party, must be impartial, and must maintain confidential. Now, I think Article 59 of the Civil, I know we are wondering, so where can you take mediation agreements? And for private mediations, if you go and register them in court, then they can be enforced by the court actually as orders of the courts. For the mediation that are annexed to the courts, as in you're given a case that has been in court, it has been screened, and you're appointed as a mediator again, that order is filed in court. But what is interesting is that the proceedings, the notes, anything you write during the mediation session is yours. Ni yako peke yako. Actually, you don't write, you only write your own notes. But there's nothing out of mediation that goes to another party. So confidentiality, which is very useful in our employment spaces, because we don't like our things being known. So it is such a beautiful and a fantastic way of resolving disputes compared to even going through a disciplinary process where everybody from the time that email or letter is drafted about you, everyone in the organization knows that you are late, or you're drunk and disorderly, or you had, I don't know, harassment, whatever case. So very confidential. So there are no proceedings, there are no notes, you only give what has been resolved. Simple, straightforward. Discussions are not recorded anywhere. And even when you go to court to record a mediation agreement, no one will ask you, give us the proceedings, or give us the pleadings. The pleadings are the documents that are filed in court. So the role of the mediator, again, is to build rapport and trust with the parties. For mediation to work, the parties must trust. They must trust you. So again, a lot of training in terms of professionalism and managing the process, and how to win the rapport, and how to go beyond like a wall. When you hit a wall, how do you go past that? You're trained in that. And how to gain the parties' trust. For instance, you're mediating between in employment space. You're mediating a high-level matter where, for instance, a director is suing the company, and you want this company to believe that you are a certified mediator. There are skills around that. Okay, I had talked about voluntariness and informed consent. That one has to be ticked in our checklist. Consent, you have to obtain consent from the parties, actually in writing. Confidentiality, I have talked about that. Impartiality, you're very neutral. Empowerment, you lead or you facilitate the parties to make their own decisions. They're the ones to decide the outcome. And actually, where your efforts have hit a snag totally, you've done everything, then you have no further obligation. You just record a statement and say that the mediation was unsuccessful. So empowerment, you are required to empower the parties themselves to come up with their own solution. Flexibility, it is very flexible. Okay, it is not cast in stone. You should not say that now mediation begins at 9, ends at 5. No. That we must finish today. No. It should be very, very flexible so that you accommodate the needs of the parties and the nature of the disputes. And then I had talked about these very critical skills that you're trained in as a mediator: communication skills, very, very important, because you cannot be a mediator if you're very talkative. You must learn how to listen and listen when you're Richard. Active listening, okay? Because actually, I remember when you were being taught mediation, you were told when a party is talking, you need to stop everything and listen to them. And actually, what comes into my mind was if we think about mediation and we think about Kofi Annan, I don't know which generation that I am speaking to, but I want to assume that maybe a fair share of us know or knew Kofi Annan. He's late. And in anyone can tell us what do we remember Kofi Annan for as a country? Maybe somebody can there's no free or there's no wrong answer in an adult class. Somebody to remind us.
We refer to it as nusu mkate.
Yes, Mary.
Somebody has spoken about nusu mkate.
Okay, I think we remember the election for, it was 2002 or 2007. Yes, he's the one who brokered the nusu mkate, isn't it?
Mm-hmm.
So when we are thinking about mediation, that is like the ultimate kind of disputes we need to Thank you. What else? Richard, you can read for us what is in the chat.
Very good. Kemi Nduta has said he helped.
Yeah, I can see he helped Honorable Mwai Kibaki and Honorable Raila Odinga come up with the nusu mkate. He helped put an end to 2004 post-elections commissions by mediating between our political leaders. Exactly. And very good. Let me clap for you. Anybody else?
I can also
add. Miri Murike has said that we remember him for mediation.
Yes.
So you can see the power of mediation. So because that time, Honorable Raila had actually, and many Kenyans had actually said that they do not have faith in the courts. And again, that is exactly the same place where we are. Maybe not have faith in courts, but the courts are overwhelmed. So mediation can resolve those manner of dispute. But look at the kind of person that Kofi is.
Mercy, we have lost you.
Richard, we are losing you now. We can't hear you properly.
Oh, okay. I thought I'm the one losing you. It's okay. All right.
But we have seen what Kimin has said, and thank you for that. Thank you so much, guys, for your participation. By the way, remember there's an award for active participation.
Yeah.
So if you would ever want to
Rhoda has her hand up.
Yes, Richard.
Yes,
Richard,
Rhoda.
you're breaking. I think your network is also misbehaving on your end. I have seen a hand up. Is there anybody who has put a hand up?
Mercy, actually, it's your network.
Oh, sorry. It is my network that is misbehaving.
Yeah.
Yeah.
Oh my God. Okay. Wow. Let's try and see. But I can see I have full network, surely. What is the problem? Let me try and switch one more time.
Now we can hear you. You just break often.
You can hear
Yeah.
now?
Yeah.
Mm.
Okay, thank you for that. So what I was trying to say is that when you think about successful mediators, and coffee makes tops my lists of very very successful mediators in terms of everything. He ticks all the boxes for a successful mediator. If you look at his demeanor, he does not look like a person who is abrasive. If you look at his what he's credited for, the kind of positions he held before, he qualified to be a mediator. So as you begin your journey, hopefully as a mediator, then you need to build your character in terms of character, professionalism, so that you have the credibility to earn or win the trust of the parties that you will be taking through mediation. So I was talking about active listening before I detoured into other things. Very critical. Ability to clarify issues and summarize issues. I have taken you through what a conflict is, what a dispute is, what are the underlying issues beneath a dispute. You should not ever forget that whenever you're resolving a dispute, even in your family. Okay, and then the last one, effective questioning, another critical skill that is very useful, and that one you will learn if you go for the practical mediation classes. Effective questioning, because you need to rephrase issues, you need to paraphrase, you need to get exactly what this person is saying. You need to hear them and hear them properly for you to be able to resolve their disputes. Otherwise, the agreement will not be a solution to their problems. We go very quickly into mediation and other ADR. Here and there have mentioned a few benefits, but some of the proclaimed advantages are a win-win, because again, solutions are proposed by the parties themselves after rigorous, session of interrogating issues and understanding what is it that they are fighting over or they are disagreeing on. We've talked about speed. It can be very fast. It can be one session. It can be a couple of days. It can be a couple of months, but certainly faster than the litigation way. Privacy, yeah. A mediation session, by the way, is only attended by the parties and people that they have allowed, and not necessarily legal professionals, but should they require lawyers, they can come there. But there are also ground rules. They do not participate in the mediation process. You just come in and sit. Hautakuja hapo uanze kusema huyu ni kijana yangu, nimeelimisha, nimefanya nini? Hapana. Unakuja unakaa chini kama mzazi and you just listen. You can consult outside, you can be allowed to consult, but the person who will be representing the issues will be the parties themselves. Low costs, very cost effective. If you look at the costs of a dispute, actually, from a litigation point of view, is extremely, extremely expensive. Flexibility, we have talked about flexibility. You don't have to meet in court. You can meet virtually. It can be held in the office. It can be held in a restaurant. It is you as a mediator to identify a suitable place to conduct the suitable place, time, and all that to conduct the mediation session, again, based on the interests of the parties and the nature of the matter. Informality, it's not bound by any legal procedures or laws or rules. We'll not come here and start saying, this is what this law says. We'll not look at precedents of the Court of Appeal or the Supreme Court. We'll not look at anything. We'll just discuss issues and come up with solutions. Party control, the process actually places the parties at the center, as opposed to where you go and your dispute is in the hands of the court. So the parties are in control, and then preservation of relationships, very critical. Very, very critical. In mediation or in ADR, especially mediation, AJS, you preserve relationships because again, once you realize the real issues beneath the issue that you're seeing, yeah, you're able to mend relationships. Maybe it's a family dispute. Okay, well, I know we are not discussing family disputes. We are discussing workplace disputes, but family disputes, you resolve, you know, relationships. Not like in a court whereby you're told now, you have been granted divorce. What does that mean, honestly, for those two people? And by the way, I can confidently say that people who have gone through divorce hardly heal. But when you take a separation or a divorce matter through a mediation process, you restore relationships. In as much as these people may not continue living as a couple or as a husband and wife, they will have better relationships. They will continue communicating. The kind of solutions that they will come up with are solutions that will enable them to continue supporting the family, being there maybe in terms of, you know, there's that continuity of relationships as opposed to whereby you go to court and you're given an order. Similar for all manner of cases, even in an employment dispute, for instance. If an employer has to let go of me through a mediation process, we can end the contract in an amicable manner, such that if I want a recommendation, like honestly, for someone like me who has worked for judiciary for donkey years, if I apply for another job and they want a recommendation from the judiciary, it is very possible that I get a recommendation. But how about if we tulipelekana kotini? To be very ugly. Actually, they may not even require to write to the judiciary, but you just, you know, you go to Kenya Law and search for Mercy Mirigi and your name pops up that you had labor disputes in this and this manner of organization. So preservation of relationships, very, very critical even for our scenario. So we can proceed. Okay, so bringing it closer home, benefits of mediation in the workplace. We are almost closing. We should be taking a water break in a short while. Similar to what I have said, and in terms of costs, I know we are aware about the cost and the cost drivers. Cost is just not money. Cost drivers are many. If you look at the hours that people are not contributing to the objectives of the organization because they're in dispute, that is the costs. If you look at the people who are handling the disciplinary processes, they are not doing anything else. When they are sitting in those meetings and handling discipline cases, they are not doing anything else. Okay. If you're going to court, that one is even guaranteed. The costs associated with that are. And then again, most of the times you find that the matter is stayed, so you don't know whether, or you're given an order to continue a stay order, for instance, from suspending this person. Sasa huyu mtu aya anakuja kwa ofisi lakini haumtaki. What kind of a scenario is that as an organization? A lot of costs going into that. Time efficiency, we have really delved into that. I will not over-explain. Relationships, again, confidentiality in the context of our workspaces. If we embrace mediation, we'll be able to preserve confidential information for our employees, which is very, very critical. Let me tell you, again, without going into, over talking about the iceberg, something as petty as my issues being known in the organization might, make me to be such a hopeless or useless employee. A person was performing very well, but because issues to do with their anything to do with their work is now brought to the fore, then they change and they stop becoming performers in the organization, or they change. They no longer are team players. Yeah, which is very sad. Okay, flexibility. I will not over-explain that. Empowerment of employees, enhanced communication skills. You can imagine a scenario whereby we have several people being trained as mediators in an organization. All these people have fantastic communication skills. Employee retention, again. Because people are not leaving the organization. I gave an example. People are leaving an organization because of different reasons. Maybe it's because of other reasons, but the real reasons we are not resolving them. Improved organizational culture, very critical. We build an organization culture whereby people know that they can speak openly. There's open communication. Their issues can be heard and resolved in a simpler manner. Positive organizational image, compliance with legal and regulatory standards, increased motivation, enhanced adaptability to change, and continuous learning. Because again, mediation requires that you continue learning, you keep on going for refresher courses, you keep on enhancing your skills. And at the same time, you continue training people in the organization about mediation so that it can become part of the organizational culture. Let's move on. Okay, so criteria for selecting cases. I think we can have a water break before we delve into this. Richard, how many minutes would you want to give us? Maybe
we can have 3 minutes, 3 to 5 minutes.
3 to 5 minutes. Grab your bottle of water. Work-life balance, manenos. Stand up and stretch, breathe in and out.
Virtual exercises, stretch.
Yeah, stretch.
We are told that the latest form of smoking is sitting for long.
Yeah, whatever that means. Okay, let me take some water, then we can continue.
Thank you very much. So far, so good. I'm learning a lot of things. The iceberg, that sometimes problems do not seem what they are.
Welcome back. Welcome back. Are we there? If we are back, give me a thumbs up. I need to know that we are back and we are still following. Thank you, Jason. Thank you, Amina. Thank you, Beverly. Thank you, JD. That's very encouraging. You know, you could, Roslyn, Hadija, Mary, Asante, Nisana, Doreen. Beautiful. Wow. Asante. Rhoda, thank you very, 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 very much. And George Goya. Rahab, Winnie. Those thumbs up are coming up fast and furious. Yes. Richard, you can be sure we are creating a community of mediators out of this webinar. And believe you me, we are going to move forward massively. And as I have said, the space for mediation is very huge. We are going to turn around our organizations. If our organizations don't want to be turned around because it happens, we are going to turn other people's organizations. There are so many cases, there are so many disputes out there. So let's believe that we are beginning this journey together, and we will see. We will come back here to give thanks that this webinar happened. All right, back to our presentation, criteria for selecting cases. Okay, so for us to determine the appropriate methodology of resolving the cases, there are several criteria, but fortunately for employment cases, they fall under employment and labor, which again falls under civil matters. Why I'm emphasizing about the classification is for just general understanding. We have criminal cases and civil cases. At the moment, criminal cases are not referred for mediation, or it is not recommended that we handle criminal matters. However, all civil cases, including labor, employment and labor disputes, can be mediated, and they are allowed to be mediated. So number one, for us as HR practitioners, we are safe. All cases related to employment can be resolved through mediation. Okay. Apart from those, I will just mention.
Have a hand?
Sorry.
Okay. Oh, Juliana. Thank you, Juliana. You can unmute and raise the issue. Juliana?
I think it is by mistake, probably.
Okay, then let's carry on. So we are going to be looking at fundamental questions to be asking ourselves. Of course, I'm hoping that beyond the labor and employment space, we become mediators and we can handle any other cases. So number one, we ask, is the dispute suitable for ADR? And the beginning conversation could be whether is it a criminal, does it have any criminal components, or is it a civil? For criminal, of course, you refer the parties to the appropriate agencies. If it is a theft case, then you refer them to the police and that kind of a thing. So you do not handle criminal matters. However, I mentioned about alternative justice systems, AJS. What is interesting is that AJS actually has become even more daring. It handles even the criminal matters, regardless of whether they are petty or huge. That would be another conversation for another day. But that tells you that the shift that I mentioned about not relying on courts to resolve disputes in the country or in our societies. We can proceed. Oh, sorry. The other one was, what are the goals of the parties? Because again, it is the parties to be very, you need to assess and see what are the goals of these people that we have. Kuna wale wa lazima tupatane kotini. Now, if people are coming for mediation just for the sake of it, and this, you can be very sure that these people are not committed, or they do not respect that mediation actually will enable them to resolve the dispute, then you put your tools down and leave them alone. So what are the goals of the parties? Is it to resolve the case? Is it to waste your time? Is it to come and showcase their power, imbalances of their power, thereof? So again, as a mediator or through mediation training, then you'll be facilitated to determine how to screen cases for mediation and identify the goals of the parties. Moving on to the next criteria for selecting cases. So some of the clear indications, which are again related to the benefits, okay, of ADR, whereby parties want to preserve relationships and existing relationship, that becomes an automatic case for mediation. We are friends, we have been neighbors, this is my child, this has been my employer. Those are very easy cases for you to determine that there are cases that should be taken through mediation. Cases that require sensitive information to be remain private. For instance, in family disputes, honestly, a lot of linen is washed out there in the public when people take their matters to court in family disputes. That's when you'll come to know, oh, huyu alikuwa sijui nani, hata mtoto wao wa pili hakuwa wa huo, you know, those kind of things. And yet, if it was resolved quietly, those issues would not have come to the fore. Again, you preserve the dignity of even the family. You can imagine later on now when, you know, people insist tunataka DNA. So what? Where will that child? Because that child would eventually grow. So what happens to the life of this child? What have you done to this child by disclosing out there that, you know, this child was not born out of, I don't know, see what Richard, let me use Richard here. So Richard, if you have issues with family, kindly recommend that go for mediation, because there's a lot of confidentiality there, and confidentiality goes beyond what we are just saying. I've given an example of a child. Remember, this child will grow one day. They will go to school. They will be in the society. If you expose them in such a manner, then you have destroyed completely this person. We had talked about cases that may not be properly or cases that cannot go through mediation. We had talked about criminal. We had talked about cases of public interests. We had talked about, there's also another category of cases that probably the law prescribes must be resolved in a particular manner. You'll find that there are those clauses in laws or in contracts whereby there's a prescribed methodology of resolving a dispute, maybe through conciliation or through arbitration. So those ones, again, you do not touch. So we can proceed. I think these are notes. We can read this later on. But essentially what we are saying is, for us, all employment cases can be determined through mediation. So the others are not, it's beyond mediation, it's actually the entire ADR considerations. And if we take some time and internalize, what we are saying here is we'll be able to advise or to guide or to understand. When a case is brought before you, when someone tells you I have this dispute, then you're able to quickly or take time to screen and see, this one I cannot touch because I'm not allowed either by law, or the parties are not in a position to consent. Like, for instance, a children's matter, maybe a defilement case, a child cannot be able to consent to mediation proceedings. Okay, so that one also you can't touch. And that's what we're talking about, maybe a case where there are power imbalances. You realize that here there are power imbalances. The parties are not coming, the party A will not be able to engage the other person. So where there are clear indications of power imbalances, then again, that case may not be appropriately resolved through mediation. Although again, as you go through your mediation training, you'll be taken through a session of how to deal with power imbalances in a mediation session. When you realize that this person is very strong and probably is trying to put the other party down, then you have skills or a skill set to handle that. Okay, we can proceed. Councillor Christina has raised her hand.
Okay. Good evening.
Good evening.
My question, I think someone raised the question in the chat. I know there will be a session of Q&A, but now that you're on this point of power imbalance, I just thought I should ask now so that you can probably deal with it once. So like, how do you deal with the issue of power imbalances in employment places? Because, okay, I'm an advocate of the High Court, and most of the cases that employees bring me, the issue is usually that they're not open to engage in ADR in the workplace because there's already a power imbalance between themselves and the employers. So how do you guarantee that this mediation process will be neutral? Who appoints the mediator? Who will pay for the mediator? Where will the mediation take place? How do you make sure that this process is fair and it is like, because I think most of the employees I've come across, most of them, they actually deem to they deem to see that the Employment and Labor Relations Court is more, okay, it's expensive, yes, but in terms of fairness, most of them think that that will be fair compared to having an alternative dispute resolution. So how do you ensure that there's that balance? Because in the employment sector, the employee is lower than the employer. So how do you ensure that?
Thank you, Council. And it's good to have you on board. Thank you for bringing that perspective. So I will look at it from a mediation perspective in a practical manner. So assuming that you have an employment matter referred to you, okay, I am Mercy, I have gone to sue my organization, and the employment court has referred this matter to you as Christina for mediation, okay? So in the mediation, you will have the representative of the organization, the one who is authorized to enter into concert and mediate. Probably that is, could be the CEO, could be the HR, or yeah, maybe essentially those two. Then you have Mercy on the other hand, who is an employee. So during the mediation session and through the training that you have been given, your first requirement is to explain what mediation is to the parties. So you're telling them that this is a mediation session. I am Christina, and my role is to enable us resolve these disputes. And then there are set ground rules, okay? There are certain ground rules that the parties must consent to before you begin the mediation. And one of them is power plays. Power plays is where now, the stronger party, or like for instance, the employer in this case tries now to bring the issue of you're my subordinates, yeah? Who are you? You're my subordinate. Actually, there are a lot of, Christina, when you go through the training, you're taught a lot of things, including the setup for mediation. The setup for mediation depicts a neutral, a neutral setup, as in we are all sitting together. And for purposes of the mediation proceedings, we even are taught how to introduce ourselves. You introduce yourself and you drop your position. You remain Christina and I am Mercy. And then as a mediator, again, you're taught on how to deal with the power plays. Whenever there's an issue of power play, you remind them about the ground rule. You may not condemn, you just remind them. Again, we said here, it is not about position or power. For the purposes of this session, we are all parties, and that is the end of the story. Okay, so that is how I would explain about it from a very practical manner. But outside now the employment space, there are cases like, for instance, you realize that it is a national, like Kenya versus United States, those huge it's an economic issue. You're dealing with a small country, a bigger country. So you screen the case and see how is it really a case for mediation, or there's a better methodology for resolving the dispute. But as long as the parties agree to go through mediation, then as a mediator you're trained, or you'll have skills, and you're backed by the ground rules for mediation. Remember, I mentioned that mediation is conducted in a very structured manner. There are ground rules which the parties must consent to before the mediation begins. And if during the process you have tried your best and you realize that this party is not complying, then you terminate the mediation process, and parties then will have to look for alternative ways of resolving that dispute. For a case that has been referred to you by the court, you'll just tell them. You go back to court and say, unfortunately, we could not reach an agreement because of 1, 2, 3. Whatever was uncooperative, or they were unable they could, so and so was not respectful or following the ground. I mean, there are those set of rules that the people participating in a mediation process must adhere to. And you as a mediator, you must always bring them back to the process. The process. So you're stuck with the process, and you have to know it like at the back of your hand. What do I do should this happen? And you take charge. I don't know whether I have answered you, Christina, for now.
Yeah, I think the additional questions I can address them during the Q&A.
All right. Okay. Thank you very much. So we can proceed. I want us to finish the discussions by 8, so that we have sufficient time to address a Q&A maybe in 30 minutes. All right. So in terms of the goals of the parties, these are some of the issues again that will enable you determine that this is a case that can actually be dealt with through mediation. They need to. I had talked about confidentiality or privacy, whether a president is required, reputation of the organization, the costs, the process and time it might take. And remember, by the way, the time and the process, you know, like this, if you go to like ELRC today, the earliest date you'll be given for hearing might be in June. So if you have parties and they have an employment dispute, and you give them that, and you are aware of that kind of timelines, then the parties are more likely to agree to go through mediation easily than those people who probably think that if they go to court, the matter will be resolved very, very quickly. We've talked about preserving relationship, desire for non-legal solutions. There are people who actually don't want to go to court, whereas there are those wale watukutane kotini, those who want to have their day in court, especially, you know, the who and who. They just want to go and be seen, accompanied by their lawyers, the lawyers who are trained in Harvard, and they only practice in Nairobi and not in Mashinane. You know, people have their own problems, complexity of the issue, need for a final and binding determination again. And we have said that cases that are dealt with through mediation are actually determined, provided that they have been done by a certified professional mediator and the number of parties involved. But essentially, all cases can be resolved through mediation, so long as they are not criminal in nature, they do not represent public interest cases, and those are not explicitly prohibited by various statutes or laws. I think that's it for determining cases for mediation. So we look at communication skills. We had covered this, so I don't think I need to belabor that. So where do we start as HR professionals? Because I know mediation is not embraced in most of organizations, and that is why we have a challenge. That is why we have, remember the 64% of the cases we said are unresolved and they end up causing more problems in organizations than not, is because we are not resolving disputes. So with that in mind, it is very critical that alongside other policies in HR, we begin to think about developing mediation policies. Yeah. And we are the champions of these kind of policies in our workplaces because they are new, they are in areas of, they are emerging issues really. And we need to drive that conversation that there needs to be a mediation policy in our organizations. Why? Because of the many benefits that we have outlined here before. Okay. We can also promote mediation-friendly culture. All right. And, you know, culture is not just developed one day. It requires an entry point. It requires buy-in. It requires change management until people are embrace mediation, until people are confident that if we have a mediator in the organization or if we have a dispute, instead of taking it through the disciplinary procedure, let us refer it to a mediator. And an organization can, you know, you can have your, like the way we have pre-qualified suppliers, we have all these banner or service providers. It is a high time that we also, some organizations have, like the banks, it's the high time that we also promoted having a panel of mediators who can handle our disputes. Provide training for HR and employees. Of course, I know HR, we could be the first point of resistance because we are looking at, we don't understand mediation in the first place. Probably we also have that bias of, you know, we must go to court. We must have disciplinary committees because that is how we have been trained, or that is the orientation we have. But what we are saying is there has to be a shift, and that begins with training HR and training employees also, so that they can understand what is mediation and how is it important, and trust that it can actually work. I had talked about selecting, I had not talked about that. Select and train internal mediators, that would really work. But this might require very progressive organizations. It's like where we have employee assistance programs, and you find that where you have counseling and psychosocial within the organization, maybe employees don't go there. They prefer to be referred to maybe providers who are recommended or selected by the organization. So this may work with a lot of culture change discussion. So select and train internal mediators, even if not just for, you know, the formal mediation benefits sake or processes sake, but if you have internal mediators, they are able to address a lot of conflict in the organization without even necessarily having now the formal, you know, mediation aspects in the organization. Integrate mediation into HR practice. I think that one I have said. Establish mediation champions. This is again critical. Whenever you are introducing a change in an organization, you need to establish champions because people tend to associate with their own. You begin with converting some who then go converting other people, and then we can all embrace mediation in our workplaces. Monitor and evaluate mediation programs. You need to have an evaluation mechanism so that you continuously improve or change or redesign. If it is the policy, look at whether it is working. If it is the mechanisms you have, if it is the referrals you have for mediation, see whether they are working. If it is the internal mediators that you have trained, evaluate and see whether since their training, are there improvements? If there are maybe challenges, then you address the challenges. But what I can say is that regardless of the outcome, we need to drive the conversation about embracing mediation in the workplaces. Address barriers to mediation, so many of them: perception, lack of awareness, threats. Like for instance, for the courts, the greatest resistance to mediation and alternative justice system probably was, although not spoken, was from the judges and the lawyers, the legal fraternity. They imagine that tunachukua kazi yao itaisha. But the truth is, kazi ni mingi, haiwezi isha. Actually, it has been declared that even the cases, which are about 17% of the disputes that are brought to the judiciary, tumeshindwa. So wakili, judges, people in the legal profession need not to be worried about mediation. And so, for instance, in the organization, those who are worried about, especially those people who sit in the committees discussing disciplinary proceedings, yeah, looking at was a show was later issued, is of it. Why don't you just address the issue? I've given an example of that guy that was given permission to go and bury a relative, and it became a dispute. And what they needed to do was just to understand that this person required a little bit more time to lay their life, and then atarudi tunatendelea na kazi. So address barriers to mediation, whether they are from the management, from the employees, and see what is it, why are they fearing mediation really? Is it because they wanaona kama kazi ya committee taisha? So what they constitute other committees, those who like sitting in those committees. Encourage early intervention. I talked about the process of a grievance, moving towards a conflict, and then becoming a dispute. Early intervention. Celebrate success stories, very critical. Document your stories. Let people give stories and explain how mediation has enabled them either to restore relationships within the organization or to, resolve an issue that maybe was imagined. It could be something it could be something very petty. It could be workspaces that we are fighting over. And maybe because I don't like the way you come in the morning and place your navy blue, mug next to my lap, those small petty issues. And then before you realize, people are really, really in serious disputes. And then adapt and improve. I think that should be the last slide. Was there? Let's see what's next. Way forward. We can have Q&A, then we can come quickly and summarize this. So over to you, Richie, for
Thank
Q&A.
you very much. We can appreciate Mercy, who has done a commendable job, and you believe that she has. I can see Rosemary, I can see Mary, I can see Beverly, I can see Karum Gadi, I can see Rahab, I can see Jerry, I can see Susan, I can see Beverly again, I can see Anne, who have appreciated the energy that you managed to carve for this conversation that is important. In fact, as you proceeded, I thought that you even answered Council Christina on how to manage situations of power imbalance, training, culture modification, that is culture transformation, making sure that there are policies, even powerful people within organizations, when they understand there are policies, they tend to toe the line. Thank you very much, Mercy. Now, let us have questions. Those people who have powerful questions, those people who have very good questions, because we've been told that when you're doing a mediation process, you must have very good questions. You must question certain assumptions, you must question certain facts, so that you can be able to dive into them. The iceberg. It is the questions that go into the iceberg. So if you have a question, you can unmute and give us that question. If we do not have a question from the audience, but let me not assume, you have a question, kindly put it forward. As we prepared our questions, Beverly, do you have questions? You can read some of the questions.
Maybe, Rhoda, you can unmute and ask.
Rhoda Zoma, hello, yeah. I saw that we have two Rhodas here, but this is Rhoda Zoma. I would like to ask Mercy, thank you so much for the highlights. What I wanted to ask is okay, where you have said that matters in court can be mediated, and my question is, so who initiates this? Because we have lawyers who are already representing clients. So where should the process begin? Are lawyers mandated to ask and lead the mediation process? That would be my question for now. Thank you.
Very good, brother. Next question. Let us have a set of 3 questions. Beverly, you can read some of the questions on the chat.
Yes. Should we be documenting notes or minutes from mediation meetings?
Good, that's the second question. Mercy, you are taking notes, yes?
Then we have, can we initiate mediation talks with disgruntled ex-employees who have already opted for litigation and the case is already in court?
Thank you. All right, Mercy, you can answer those 3, then we can have another set.
All right. Thank you, Rhoda. Thank you, Beverly, for those great questions. I will begin by the matters in court. So for the matters in court, right now we have structures for screening most of the cases in the civil courts for mediation through what we call the court annexed mediation. So like for ELRC matters, like most of the cases are screened through the mediation mechanism in the courts for mediation. And once they're satisfied that this matter should be referred to a mediation, then they write to the parties and they appoint a mediator for that matter. So that is one route. The other route is for the parties themselves. There's a matter in court, yes. Having a matter in court does not prevent you as a party or you as a lawyer to explore alternative methods of dispute resolution. What you do thereafter, you go to court and file a mediation agreement, and the court will adopt that as an order. So that one is very possible. If you're a lawyer, the matter is in court, and you think that your parties can go through the mediation way, fantastic. You go, finish, go and record a settlement agreement in court, it will be adopted. And actually, I think the judiciary will be more than happy, because this business of having backlog of cases is not serving the interest of anyone. It is not people-centered justice, it is not access to justice. So that one is perfectly in order. About recordings in mediation, I have to reiterate that there are no proceedings. You don't record discussions in mediation. You record as a mediator for your own reference. But those notes, you will not take them anywhere. The only thing that you'll be left with is a summary. This was the dispute. This is what we resolved. Period. If you want, maybe you can add issues of maybe the schedules, if at all, if they are necessary. But what I told you, what I said, and what the other party said are purely confidential and cannot be filed anywhere. Hakuna mahali unaweka hizo records kabisa. Unless wewe mwenyewe you put them in your safe for you're the only one to read. If they are not supposed to be in the office, I don't know how you will be managing those records. So just to emphasize that mediation discussions are highly confidential. The next set of questions: how can we become certified mediators? Who do you recommend for certification? Those are related. Which institutions do you recommend want to go for mediation training? All those questions are related, but the basic certification program is usually 40 to 50 hours of training. There are several institutions that provide mediation in the country. I think what you can do, we can, because we have your contact, those who are really interested, we can be able to give you referrals and recommendations, and also be able to screen. There are emerging issues around, there are new institutions, there are those that have been on board. So it is good for us that because you're going to hold us into account, to do a bit of behind the scene and see who we can recommend to this group of trainees for mediation. But literally, there are many, and from credible ones to others which are not very credible. But the basic is a 40-50 hour training program, and then you can become a certified. Then, of course, you need to continuously undertake a refresher courses for you to keep yourself abreast with the developments in the practice. Okay, so Hosea and Richard, maybe after this we can facilitate our participants on where they can be taken through the training program for mediation.
Great. Actually, we have created a group and I've shared the link. We will be sharing more information on where you can get mediation academies and schools where you can get certified. It is another revenue stream, I believe. Don't you think so, Mercy? You have that certification, you can be called up, right? Let me know as a certified person. Tell us something about it. Averagely, what is the fees for?
Uko pesa ni wewe utate. I mean, there are guidelines, but believe you me, it is really flexible. It is very, very flexible. And as I have said, you can mediate any disputes as long as you have been trained and you have the skills, you believe in yourself. Even Raila and Kibaki, you can hack, because it is the ground rules and the skills are so fundamental. Once you're armed with those, then you can be able to really assist people in resolving the disputes. And the fee you charge depends on so many things. You can charge per hour, you can charge per day, you can it's flexible, really. Yeah, it's very flexible. But it's an alternative. Let me use alternative also. It's an alternative revenue stream for those of us who are here this evening. So if you're complaining you don't have money to take yourself for holiday next year, can we start this journey today? Then we can show you where to get that money.
Very good. Another set of questions, Baby.
Yeah, there's a question from Rosemary Muniu who says, what are the requirements for a mediator's summary of resolutions to be accepted and enforced by the court?
Okay.
Let me begin. What are the requirements for a mediator's summary of resolutions to be accepted and enforced by the court?
Thank you, Rosemary. The summary of requirements. The summary of requirements are basically the parties, okay, the names of the parties, yeah, and the nature of disputes, and what the parties have agreed. That's it. I have agreed to pay Richard 150,000 Kenya shillings end of this month. That's it. As simple as that. And there is no legal jargon there. Just straightforward resolutions. Straightforward resolutions. We have agreed that we will allow the children to be visiting the mother, in alternate weekends. We have agreed that the piece of land be subdivided in this manner. First wife gets this, second wife gets this, third wife. Simple English language. It is the parties who are telling you. Actually, we are the ones who complicate people's problems. We complicate people's issues. Kenyans have very normal problems. Employees have very normal problems. We are the ones who complicate them with a lot of English and a lot of jargon and saying that a person wants to hear with. No. Just say these are the parties who came to me. And then this is what the parties agreed, and they sign, and you sign below. Period. That forms a basic agreement. You won't be asked to say how many sessions you had. You won't be asked to say when the dates actually we met, so that you can show this was a very difficult case. We met 3 months. We met for 3 months. No one will ask you for that information, and it is not required. parties, and this is what we have agreed. Actually, you don't even need to summarize the issues. You just parties and agreement and signature. That one is adequate. But again, you could be given basic templates, but with that understanding that you don't need a lot of information, just record the agreement and you take it to court. That is fine.
Thank you very much. Do you have another set of questions, Beverly?
Not really. The chat is clear.
Okay, we can have people unmuting themselves. Council, Christina, you promised that you are going to give us some questions. So this is your turn to give those questions. Even comments, if you have something to add, answer what Nancy has said, you can unmute and proceed.
Okay, thank you. Thank you so much, Richard. The session has been very enlightening for me, especially from a legal perspective. I got to see how the employer side can incorporate this mediation. And did I have a comment? Oh, there's someone who asked whether lawyers are important for mediation, and I think yes. Yes, because I've had the privilege of being an in-house counsel and also practicing in my own firm separately. And I think the role of lawyers comes in that the mediation agreement is still an agreement. It's still governed by the laws of contract. And an instance that I can mention is there's this agreement that a very big employer, it was an IT company, they agreed with an employee. It was in form of I don't know if you've come across these mutual separation agreements. They are in the line of So following mediation, they came up with an agreement and a separate mutual agreement. But what happened is that one of the terms that was agreed upon was that this employee was not to practice. It was some sort of an non-compete clause, whereby upon termination, upon payment of the dues, it was a mutual separation, upon payment of the dues and all that, he wasn't to practice in his line of work for a period of 6 months. So the document was signed, the employee received whatever was due to him. Then later he went to court, and it happened that the court said this contract was unlawful. So based on the fact that when you go back to the right of I don't know how to frame it, but the right of a person to earn a living, it's a constitutional right, the right of employment, the right of fair earning and all that. It came back to that, and the contract was voided based on the fact that it was unlawful. And such a term, it was made that because of the power imbalance, the employer was probably infringing on the rights of the employee, and such a term that this employee cannot practice in his line of work for a period of 6 months in this particular county was unlawful, and that made the contract void. So probably what I would advise the employers that you can, even if it's in the line of ADR, you can probably involve a lawyer, and even an employee. Nothing prohibits you from choosing a representative who is probably familiar with the contractual terms, so that you know what you are entering into also. So that you can have taken time to go through the mediation process and end up in court and the whole thing getting voided. So just involve the lawyers so that we can make sure that the agreements are actually constitutional. Nothing can later come up and void the contract. So probably I would say that is the role of the lawyers, just to make sure that the terms and the conditions that have been agreed upon are actually lawful in the first place, so that the same cannot be vitiated. And what else have I seen? Yeah, I think that actually mediation is a great step. Some of the cases that I've seen that have been dealt with in using mediation in the employment place, things like sexual harassment. I think that it's something that you can actually put in your sexual harassment policies, because both the victims and the perpetrators, they would actually value their privacy, which is one thing that ADR actually promotes. So you can have a policy you can just have like a conversation, just as easy as the speaker has said. Yeah, so those are the things that you can actually deal with in mediation, things like sexual harassment, things like deterioration in performance. It doesn't have to be employee to employee basis. It can also be a conflict between the employees and the employers, and I've actually seen them work. So yeah, the whole session has been very enlightening, and I've learned a lot. And yeah, thank you.
Very good. I can see George. George, your hand is up.
Yes, thank you so much. First and foremost, I would like to appreciate the session has been very good. I have only one question in relation to the mediation and the policies. First, it is indicated there that the mediation, the agreement between the parties are one, private and confidential. So my question is, in case the agreement has been reached by both parties, which need some kind of implementation, and in case of a breach of such an agreement, what next? Thank you.
Very good, George. Another set of questions or comments, then who is banning the comment? Okay, Mercy, you can answer that question by George, then we can come to comments or additions. Sosa.
All right. So thank you very much, George, for that question. So in terms of implementation of the agreement or enforcement, you know, you register if it was a court annexed mediation, if it was a matter that had been referred to you as a mediator by the court, you take the agreement to court as it is. These are the terms, okay? And the court now can issue that as an order for implementation. But remember, what we are saying is first and foremost, enforcement or implementation of mediation solutions is easier because it is party driven. We are the ones who have come up with these proposals. So one advantage is that it is much more easy to implement, other than when the court makes a pronouncement over a case. Okay, so those are two distinct issues that we need to remember. That as a mediator, your role is to reach parties towards a mutually agreeable solution. So you don't need again to necessarily go around with a whip or a court order to enforce. But should there be a breach in terms of parties' obligations, then the court can enforce, and it will enforce in the normal manner. You don't require proceedings. Now, in case of non-agreements, because sometimes you're unable to reach an agreement with the parties, so the pleadings, the documents that were in court will be processed the normal way. So the documents are there. No one will ask you for evidence. No. You forget about mediation totally. You forget that it ever happened, and now you start with this case be mentioned today. This case will be heard tomorrow. Bring your witnesses. The judge writes the judgment or the decisions based on whatever it is that they base their decisions on the laws, the evidence, merits, and all that of the case. Okay. So if the mediation does not reach an agreement, then the court reverts. It will start the case again. It will prosecute the case again, like it was a normal matter that never went for mediation. So that is the beauty about mediation. But I can be sure that nobody will ever ask for mediation proceedings. I think that was the question. Was there a part 2 of that? And I agree with Beverly that it is good to consult lawyers. Of course, it is good to consult lawyers again so that you can have constitutional and legally binding contracts. But again, in the ADR spectrum, it is not about the law. It is about the interests of the parties, and it's about what they have agreed themselves. Of course, again, we had said about the cases that cannot, pass for mediation, things that regard public interest, that things are not constitutional. Of course, you're not going to come up with an agreement that contravenes the rights of a person, the rights of a person. So yes, it is important, but again, not mandatory. And again, I said, mediators, any profession, if you're a musician, if you're a lawyer, if you're a doctor, you can learn the mediation skills and become a certified mediator, recognized for all intents and purposes.
Very good. Hey, Mercy, you've chewed this book for mediation. You really understand the nuts and bolts. Yes, anybody who has a comment? Anybody who has a comment, an addition? I am sure there are people who are itching. I don't know why they're not raising up their hand to make additions.
Hey, Coach, let me contribute something.
Mm.
In my workplace, we used to have a written form. After we used to be sent to the head of the management. And in this particular form, it has a section for recommending a solution in which the grievance can be addressed. Yeah, so I felt it saved on time, because the employee has raised a complaint and also a possible solution to the complaint. So you don't have to waste time again coming up with a mediation committee or trying to find solutions by yourself, because the employee knows best what their emotional needs are, and by suggesting solutions, it becomes easier, and even it saves on time for resolving the conflicts that may lead to disputes.
Very good. I'm happy that you are echoing the concept the employee knows the iceberg more than anybody else. So if they propose certain solutions, then that is easier. So anybody who has comments before we are almost coming to the tail end of our discussion? Remember, we have created a group for purely ADRs, and you can join so that we can see what revenue we can generate or what benefits we can generate out of alternative dispute resolution, like conciliation, yes, HR Director of the Year, Mary Riga. Tell us something about reconciliation.
I think first of all, I just want to say thank you so much for you organizing this forum. I have learned quite a bit. It's not a question I have. It's just I just want to speak into something that Mercy said, that sometimes HRs could be the first to resist mediation. But I wanted to say that as long as we acknowledge that the contract between an employer and employee is more relational and not commercial, then we ought to appreciate that ADR will be the first choice to be able to complement that type of a relationship. And so for me, this is a conversation that should be alive in organizations and should be alive in all HR forums, because then from what Mercy has taught us, particularly, I was very, very keen when she was talking about the mediation iceberg. And I realized, oh my God, the courts do not have the time to look at all of that. Yet we are dealing with an issue with a relational engagement. And so what a better way to go to be able to unpack that particular conflict mediation iceberg. So for me, I think that was the highlight of this 2.5 hour session. I'm able to now look at conflict from a completely different aspect. I know we look at many other things or through the eyes of that iceberg, but I never thought that I could actually have a problem with an accountant because he's wearing shoes that look like my friend's Richard there. But it has come so alive. It's unbelievable. I am just wondering, why am I constantly fighting with Jedi? But I realize it's because Jedi constantly, every time I bring in a new hairstyle, she goes and wears it. And every time we're in the office, she seems to have a better head shape. People compliment her more than they compliment me. And so I create a grudge. So it was such an eye opener, and I thank you so much for that forum.
Thank you, Mary Muriga, and I cannot stop emphasizing that you're the director of the year in HR, and that we need to appreciate. Probably we should call you at some point to tell us how to become the best in the business. Yes, anybody who has George, I can see your hand up, or is it the old one? I know there are students of law here. Carol, I'm sure you are itching to say something. Carol, you can say something you have forgotten to say.
Thank you. Thank you for recognizing that I'm a student. I'm also not a HR practitioner. But then my observation is that much as a settlement is achieved in ADR, do we always achieve justice, considering that most people would like to run to court because they feel that that's where they get justice? And one of the reasons that that ADR has been pushed as an alternative in Kenya, much as it's entrenched in the constitution, is also because of our courts not being able to cope with all the litigation that goes to them. So is there the feeling always that justice has been done when settlement is reached?
Do we have, I guess what you're asking, do we have a way of assessing, auditing that the objectives of the mediation process? That is your question, Mercy. Do we have auditing? Do we have a mechanism of looking at the mediation process in terms of objectives?
Thank you, Carol. I will begin by appreciating Mary for very insightful, reflections about the iceberg. Actually, the more you think about the iceberg, the more you realize that we have quite some work to do. Some self-awareness to achieve as we, deal with relationships around us. And I also want to say that, as much as I'm a facilitator, I am also learning a lot from you. And thank you so much. So Carol's question is whether ADR mechanisms actually provide justice. And my question is, what is justice? Or what is the purpose of justice? It is to resolve a dispute, I guess. I'm thinking a bit from a criminal perspective, whereby a criminal dispute perspective, whereby I steal. No, let's say probably I think we are not allowed to resolve capital offenses, but I think stealing, if I steal from you and we go through ADR and I'm allowed to return the money, or if it is not return the money, we agree on how I'm supposed to compensate you. I think justice is seen from the party's point of view, from the, let's say, the aggrieved or whoever it is that was looking for justice point of view. And if this person is actually satisfied, we are not looking at justice from the court's view or from the law's point of view or from an advisor's point of view, from from the eyes of this person who is on the table. And that is why we say justice may not be in my eyes, because in my eyes, I want to see, let's say, an issue between myself and a neighbor. I want to see my neighbor put in. No, in the eyes of all of us, we want to see my neighbor behind the bars, okay? But remember, in my eyes, this is my neighbor, okay? So beyond putting this neighbor behind the bars, as a human being, as a relationship person, what am I communicating even to the family? Shall we even ever be able to live harmoniously again? I am here, I have taken my neighbor to court, amefungiwa ndani. Ako na vijana, ako na mama, ako na watoto, ako na watu wao. How will I continue living in that space whereby the outcome of our dispute ended up putting this person, behind bars, as opposed to whereby probably we would have resolved the dispute in a different manner completely and restored the relationship. And I am satisfied that at least now I am okay. I am fine. We have agreed. We have talked. This is our solution to our own problem. So what ADR tries to promote is solutions that are party-driven, not third-party driven or court-driven. And because, again, I have listened to conversations around AJS, alternative justice systems. And where this conversation begins is before westernization. Before westernizations, Africans used to resolve their cases. And there was no categorization of whether they were criminal or they were civil, they were commercial, or whatever it is. But it is the same human beings, and they had disputes. Whether they were commercial or not, or whatever it is, we don't know. But they used to resolve them amicably. But fast forward, we transitioned from, it's something that is debatable, really. We transitioned from all those forms of resolving disputes to a place whereby now we made them so complicated, modernized, legalistic, And what now is being argued, or we are promoting, or we are shifting, even as the judiciary, and I believe the judiciary encompasses even the legal fraternity. Of course, converting people one at a time, because there are those until you come now back to the grassroots of disputes and why they need to be resolved. Then you come to realize that justice is not what we imagine justice is in our heads or as third parties. Justice is what is in the eyes of the parties, looking at their interests, looking at their relationships, looking at what is it that they want out of this matter. Again, ADR is not compulsory, and I think we need to remember that all the time. People must be willing to go through ADR. So when they are not willing to go through ADR, or whenever ADR then, in the eyes of one of them, does not look like, I don't want to sign this agreement, then the courts are there to provide that alternative. And I think as we move forward, the courts now will actually become the alternative. We do everything else and now we go to court. I don't know whether I have answered Carol. Again, yeah.
Richard, we have Rhoda. I think Rhoda has been raising her arm for a while.
Oh, yes, thank you. I'd like to say that I have a take home as part of my comment that I come from an institution where it's a public service, and we have so many litigations of staff members who feel disgruntled after being sacked. And so I want to say I appreciate this, that you're encouraging us to even train mediators in our midst, HR professionals, and also people in senior management, and even in the union level, to be able to handle these disputes such that in a way that we get out of the courts and try to settle these matters outside the courts, and also avoid a lot of costs. So I want to appreciate the fact that you're encouraging us to be HR people who are very progressive in our thinking and in our careers. so that we can be very times. Thank you.
Very good, brother. The change management of organization does not start from the CEO, does not start from this. It starts with that HR people. We are the people to plant the seeds. We are the people to plant that golden egg within the organization of how some conflicts, which are time consuming, which consume a lot of money, which spoil relationship, how they should, we are the people. We are the ones to start the conversation. If you start this conversation and the organization is culture changes, then your time spent here has been rewarded. Don't forget, don't fear, don't be anxious. You are the person to start the conversation. Any comments?
Maybe on my end, Richard.
Yes.
My thought is, if you've been through a court process, you'll be able to know that at the end, lawyers are never enemies, isn't it? And at the end of the process, you might find that whatever decision that was agreed, it was agreed by between the lawyers on how to solve the issue going forward. So I'm looking at it also and seeing that as much as the courts are overwhelmed, also lawyers need to look at it from a different perspective. That could this also be a different way of resolving cases? Instead of having a case in court for 20 years, why not find a way of gaining a certification in mediation to be able to resolve these cases off and be able to have a shorter period in solving these cases. And I think there needs to be a lot of awareness, Mercy, when it comes to mediation, because people need to be confident about it, that it will work. And people need to understand that all this is also recognized by the law. So I think maybe that would be my takeaway from the session.
Thank you very much, Hosea. That is a very good input. The last comments as we decide how do we resolve, how do we mediate who contributed more? How do we mediate? Tufungue sawa. Kuna data analytics so that we see who contributed more, who sent more emojis. In my mind, I have somebody, but I don't want to say. Can you write on your chat, who do you think participated? 2 people who participated very well. The voting has been closed. Now it is a question of you entering the name of the person you think contributed more, excluding Mercy, me, and Beverly, and Osea. I know who sent so many emojis. Osea, you can be able to see the contributions. George has left.
I'm seeing.
Yeah,
Jedi voting for herself.
She did a lot of work. She has sent a lot of emojis, and which is a warm thing. I think she rightfully wins. Yeah.
But let's continue looking at what comes. I'm seeing Rhoda, but Mercy, you can. There was a slide Mercy was to complete the way forward.
Jedi, you win. Jedi, between you and I, you've won. Anyway, I love the energy here, and I love the vibrance, and I love the challenge to all of us to arise and drive this conversation about mediation. It's not easy, but I think we are on the right course, and we will continue with these conversations for the benefit of humanity. Sometimes you need to look at things beyond yourself. You look at things in the light of other people. Yeah, if we can manage to assist resolution of disputes in our spaces as communities, then at least we'll have assisted Kenyans who I said statistics indicate are 64% who do not know how to resolve disputes. Okay. So I'm really glad and excited together with everybody else. So in terms of way forward, we need to evaluate. We were looking at getting feedback, and I'm glad that we have gotten a lot of feedback, both in terms of way forward, content, questions. Also, we were struggling with them, but those are areas again of us to do research. Such next time we have this kind of training or conversation, then we know what to address. We also need to collaborate with lawyers. That is my take home, so that we really understand, areas of partnerships, so that when we are communicating, of course, we are representing a unified approach to resolution of disputes. But again, I dare say that litigation and ADR do not conflict. Actually, they complement one another. So the conversation again with the colleagues who are in the legal profession is very, very, very critical and useful. And I believe through those kind of collaborations and discussions that will become better mediation and will become better champions, so that whenever those issues come up, then we are able to explain or address them well. So gather feedback. I hope, Jose, you're sharing an evaluation form. Then moving forward again, we'll need to look at what kind of needs do we need to address out there. That is for all of us. Training needs, we have mentioned about training mediators for certification. So that is a gap. Where are we, people asking questions about where do they get training? So that is good homework for us, and we promise that in the group we are going to be able to be addressing that. Customers training content, very critical. I believe we have a lot of training to do. We could train your managers, we could train your employees, we could train your boards, so that they wajisaidie awasaidie the organizations as well. So customized training content based on the training needs and the groups and the people we want to focus on. We'll also be developing specialized modules. So be our ambassadors, that so that whenever we come up with specialized modules, to either as refresher courses or as introductory or just for driving that conversation, then you're going to be our ambassadors. Next sessions will be incorporating real studies, case studies, practical role-playing sessions, so that we can see how exactly it works. We'll be having advanced techniques for those who are in mediation practice, in collaboration and in partners, of course, with other institutions. And then we intend to do continuous training, and that is why we have this conversation around having a network of professional HR who are in the mediation space, so that we continue to support each other. Okay. And then follow-ups, look into how we assist each other to get certification programs, continuous monitoring and evaluation of this discussion, so that we are not leaving it here. We want to be impactful. And we want, when the history of mediation is written for HR or in the labor relations space, then our names should clearly be there. Then promote mediation in the HR community. Please be ambassadors of mediation, whether you're a mediator yet or not. But I want to believe that somehow, at least some percentage, we are converted that mediation is very, very, very critical. Mediation ADR is very critical, so that you can resolve disputes. We help people live in harmony, restore relationships, communications, and we can have a peaceful and vibrant society. That was in terms of way forward, just thinking forward looking, and those are some of our thoughts. Homework for us with Richie and indeed all of us. But feel free, in the group we'll continue to have discussions and engagements and see how we work and drive this conversation together. Over to you, Richie. Many thanks for listening to my voice, my face. I promise and hope that next time I'll be in my hood. Huku kwenye niko ni kwa wenyewe. So poleni sana, and thank you so much for your indulgence. Back to you, Richard.
Thank you very much. We are the change agents. I hope you have said that in your beautiful voice. We are the change agent. Don't wait for Dr. Who is this famous person in human resource management in the world? Don't wait for Maxwell. We want to quote Maxi, we want to quote Mary, we want to quote Hosea, we want to quote Beverly, we want to quote Rhoda, we want to quote Council Christina, we want to quote Kenyans in the ADR space. We should not wait for other people to do this for us. We are the people who are going to begin to shape the narrative, the conversation of the essence of ADR in resolution of conflicts. Did we arrive at who was the most involved in the discussion? We need two people. Was there? Tumekubaliana?
I see Jason is trying to catch up.
Okay. Voting imefungwa, so I can rightly say that Jedi won, and we said two people. Did we say the gender, or what is it? What did we say? Remind me, please.
I think we can agree. The team can propose someone in the interest of mediation.
Okay. Okay. We can.
I'm seeing Rhoda. I'm not seeing Jason. Okay, Jason is Jason is really catching up. Okay, so I think if we will go with JD and Jason, and it doesn't mean that the rest haven't participated. It's just that we had to choose two. So we are grateful for everyone who attended. I'm seeing someone saying Council Christina, thank you. Consider Jason. So I think we can go with the two for today. We'll have more definitely next time, and even bigger prizes.
All right. I believe that we have come to the very, very, very end of our presentation. I will take this opportunity to thank Mercy Murigi, who is a HR expert. She's also a consultant. She's also a mediation expert. She's also into event management. Thank you very much, Mercy Murigi. I also take this particular chance to appreciate Mr. Hosea for bringing the technology, for making us have a successful, very beautiful PowerPoint presentations. Thank you very much. We also appreciate Beverly for good marketing. Thank you very much. And I hope I've not forgotten anybody. And lastly, and of course not the least, the attendees, because we cannot talk to ourselves. It is you who makes the big deal become successful. May God bless everyone.
Maybe just one last thing. So for the course itself, for the training, we will have access to a certificate which will be sent to your email. You will have the CPD point. So ensure that I'll share with you the training feedback. Ensure that you fill in the names that you want on your certificate, and also your IHRM number. I hope for IHRM members, you've been able to share. And then the last bit is on our e-learning platform. Once the course is out, we will be able to give you fast access to the course. And we'll communicate still on email and also follow up with a call. Back to you, Richard.
Thank you very much. My name is Richard J. Magoma. I am a motivational speaker. I know you do not like motivational speakers. I am a writer. I write for a very important newspaper in Kenya. Nani huyo? Now that we started resolution saa hii tu. Thank you very much. Don't forget to recommend us to various places of interest, and be happy, be cheerful, live your fullest potential. Don't hide, as the Bible says. You cannot light a lamp, is it a lamp, whatever, lantern, and hide it under the table. Please shine wherever you are. Don't wait for tomorrow. Don't procrastinate. Shine now. Tomorrow will take care of it. Shine today. Please, what you have learned today, shine. Shine. Do not be modest. Ladies and gentlemen, good night and God bless you all.
Good night. Thank you all.
Good night. Good night.
Good night, everybody.
Good night. Good night. You can say it in your language. Let us see you. You can say it in French, you can say it in Italian, you can say it in Kikamba.
Good night.
Yes. Hi, Juliana.
Good night.
Good night.
Anna, Rhoda, say it in your language. Eddie, Ebu Sema na lugha ya kwenu. Carol, say it in lugha ya kwenu. Ebu Sema na lugha ya kwenu. Anna, say it in your language.
Rara via.
Rara via. Ra, say it. Ebu Sema na Kimombo.
Good night.
Susan, good. Thank you very much.
Mukome wega.
Hey,
Thank you.
no, thank you. Very good. Thank you.
Hosea, you can stop presenting.
Oh.
Work-life balance.
Mm.
Work-life balance begins now.
Are you sure?
Bana, I'm missing a cocktail. I'm even late, Bana.
Oh, you're going for a cocktail. That is
I
very
won't even go.
good.
You need to go. Tomorrow is Friday.
Cocktail, yeah. I'm missing a cocktail now. If I go, I will even not enjoy. I'll go there with my own iceberg problems. Let me just leave people to enjoy. I'll go and start judging people. Yeah. Okay.
It was nice, Mercy.
Yeah.
It was very nice.
Thank you.
Kompyuta yako tu ndio imekukataa na presentations. Nangoja tu kipresent.
Alafu internet bana, we hata sijaelewa. Next time I think. Jose, you're the IT guru. You need to tell us how to be working. I don't know what internet.
You get a MiFi. You get a MiFi.
What? Okay.
You get a MiFi. I think but now you'll need to be switching. You can put Safaricom in the MiFi, or it's called fiber. I hear fiber is also very good nowadays.
You walk around with it?
Guys walk around with it.
Oh.
I'm also looking to start walking around with one.
I think that's the only way. Yeah.
Okay, good night, guys. Thank you very much. God bless.
Good night. Yeah, God bless you as well.
Okay, bye, Richard.
Okay, bye. Bye, Hosea. Good night.
Okay, good night.